supposed to come.
No counter.
No counter.
No.
Item 46. Item
We are
46.
for the interviews, in this case. Item 46.
Only guy, stand and watch.
Yes.
Where is the state?
State is here only.
Yeah, it's not quite.
The counter was filed yesterday at 3:50. That's why it's not reflecting. We have copies. We
We are not seeing.
will not be It was filed at 3:50 in the evening. That's why it's not reflecting in the office report.
They say it is not filed.
I have the diary number.
We'll have it next week.
Tomorrow could it be tomorrow?
All.
It's their fault, my lord. There are the two occasions now. Last time also,
Because in that case, I have it on Friday.
despite the copy, advance copy having been served to them 2 months ago.
Yes, you are asking only for that lady.
Yes, sir.
Huh? Yes.
It would be on 11th, my lord.
Right.
11.
Yes, what do you say about it?
Because in the FIR, the allegations are that she was taking hold of the
That's a matter which will have to be thrashed out today.
charge sheet. Has
Only
been
for
filed.
her. Yes, what do you say?
Yes, my intervention application is on record. Just have.
Alas,
That is there.
we'll allow you.
Yes. And then this, just have a look at what they say. She's a lady. Just have a look at.
You are doubting that she is a lady?
She is a lady, and therefore that's why she deserves bail. Just have a look at page 40.
One of the ground.
Yes, one of the grounds. And another ground is that she's named in the FIR. She caught hold of the boy. 2 boys were mercilessly murdered.
Yes, but
Yes.
who is the one who inflicted the stab injury?
My son. He's my son. One is my son. One is my
One second.
And I apologize.
Page
Who inflicted the stab injury?
5, I have drawn the chart.
That is Rupesh, is it?
Sanket.
Page is one who's.
Rupesh is the one who got killed.
Page 19.
Sanket is the person.
The Lordship says the
Sanket
FIR.
and Kamal Thakur inflicted injuries.
Huh?
Sanket and Kamal Thakur inflicted injuries. At,
Sanket,
pa- at page 5 of my intervention application, I have filed
Sanket
a
and
chart.
Kamal. That is A1 and A2. They are A1 and A2, is it?
Yes.
That's right.
For them, we will not grant it. Anyway, they are not asking.
And then she caught hold of the boy, Your Honor. 2
Along with
boys
other,
were killed.
who others caught hold of her? Caught hold of it?
This Gayatri present applicant,
Ah.
she caught hold of the boy. Then there's Dolly Thakur and then there is Sachin Thakur. These 2 boys were caught hold by 5 persons and five injuries were in.
Caught hold?
Dolly Thakur, Sachin Thakur and
One second. Dolly Thakur.
Sachin Thakur and Kamal Thakur and Gayatri Thakur. Sorry,
Kamal Thakur or Gayatri Thakur?
Gayatri Thakur. These 3 persons caught hold of these 2 boys. This is an eyewitness account. This is Abhay Jain, Abhay Baghel.
Abhay?
Abhay Jain, Abhay Baghel.
Abhay?
Abhay, he's the
Abhay
person-
Baghel and Pratham Baghel.
Pratham Baghel. They have logged the FIR.
Where is the 161 statement?
161 Street.
Where do you find it?
If you want to file.
None have been examined. Charges were framed just last month.
But the High Court doesn't say that any particular overt act against this lady.
No, no.
This account is there.
Where is that? Where is
I
that?
could say so. I have the copy. I have the copy of the
Page 4
160.
of the last paragraph.
Hmm?
Page 4 of the last paragraph.
Yes.
Where it was having considered the right of submissions made at length by both sides and also the facts revealed in the FIR written on the basis of an eyewitness account. That applicant was holding Rupesh as the deceased in a grip along with other accused when he was given 2-3 stab wounds in the stomach by co-accused Satya.
What is her age?
62 years around it. She is a school teacher.
Give the statement of the.
It's in Hindi. It's a copy of the charge sheet.
We filed the statements, they're there on record.
Where is it?
Page 21 of the
Filed by them.
file B, Manu.
Page 21.
Yes.
No. Page 21 is the continuation of the FIR.
No, Manu, IA number 263628.
You file it in installments, correct?
Manu, we filed it.
Supreme Court, no,
263628.
nothing is filed in order.
I apologize, Manu, there must be some mistake.
Whose photo you have put up in your IA for
That
interview?
lady petitioner
The lady.
holding the gun. She's fit enough.
This is a case of stabbing.
Father and son.
Manu, this is a licensed gun. Every family has it, Manu,
But that
in
is
remote areas. Licensed gun, she might have. But
Statement in the persuasion.
statement is at page 21, Manu, erection A4. He is the complainant himself.
He is comparing it.
Manu.
Any independent witnesses?
As of now.
Huh?
Only Abhay and Pratham was the persons who were there.
They are the first cousins of the deceased person. And they are so influential, my lords. Next day, they burnt the entire city, entire market, all vehicles.
Incident had occurred somewhere around 11:50 at night on 16th of May.
He said as soon as Pratham and mother of Sanket, his sister Sanket, whose name not known, all three had held Rupesh. 6 names are being shown and 3 they say it has been held. Who are those 3?
being held by these persons.
Please read that, page 22.
My copies tell us.
I'll give it to you.
My copies tell us.
I'll give it to you.
FIR, I'll read. I'll start, or 160.
Sir, the statement of the complainant,
Yes.
he says, as soon as Pratham and I reached Sanket house,
Yes.
he saw Kamal Thakur, Umar, mother of Sanket, his sister Dali Thakur, and friend of Sanket. That means 1, 2, 3, 4, 5 persons were there.
Aman is the deceased, Manoj. That might be a typographical error. Aman is the deceased. Kamal is an accused. Aman is the deceased. Mother of Sanket is Gayatri, the petitioner here.
Who are the 2 persons who got killed? One is
Upesh
Kamal Thakur.
Upesh and Aman. 2.
There is one more Aman.
No,
only one Aman.
only
the
one.
deceased.
That is, in fact,
Then there is something.
typographical error, my lord. There's only one
In
Aman.
this statement,
Aman is the deceased.
no name.
You have the original recorded in Hindi.
Yes.
I have the original record. I'll read it out to Manu.
इन्होंने रुपेश,
Page 24 is there, Manu.
I have
On the same
understood.
file. Page 24 it is there.
And-
May I read it out for Manu?
Yes.
Manu. मैंने पूछताछ पर बताया कि मैं
Reading which line, which page?
first line I'm starting.
No.
No, I'll start with the fifth line, Manu. That says, मैं रुपेश और अमन संकेत के घर तरफ जाने निकले, उनके थोड़े पीछे ही एक मोटरसाइकिल से मैं और प्रथम भी संकेत के घर तरफ गए। जैसे ही मैं और प्रथम संकेत के घर के पास पहुंचे तो देखे कि कमल ठाकुर ने अमन को, वन ऑफ द डिसीज्ड, कमल ठाकुर इज माय हस्बैंड, तथा संकेत की मां, बहन डॉली ठाकुर और संकेत का दोस्त जिसका नाम नहीं मालूम है, तीनों ने रुपेश को पीछे से पकड़ कर रखा था और संकेत ने उसके हाथ,
Read it again.
हेलो, कमल ठाकुर ने अमन को तथा संकेत की मां, द प्रेजेंट एप्लीकेंट बिफोर बैलेंस, बहन डॉली ठाकुर और संकेत का दोस्त, 3 persons, मदर, डॉटर एंड वन फ्रेंड, संकेत का दोस्त जिसका नाम नहीं मालूम, it came to be Sachin later on, my lords, तीनों ने रुपेश को पीछे से पकड़ कर रखा। Now an improbable story is narrated, my lord. 3 persons, an old lady, a young girl, catching hold of one 24-year-old young man, another young man, the 2 deceased men. Another deceased was being caught hold of by one thing may I mention, my lord? They belong to Rajput community and they always have Dashera mein they have Vijayadashmi Pujan, Shastra Pujan. So, my lord, for that purpose, everyone, even the ladies take the lead, my lord. नहीं, my lord, this was posted in the Facebook by the children. My lord, it is not a case of gunshot. It is a case of
witnesses. Who was the prime? These
though 2 witnesses, my lord. One is Abhay, and second is Pratham. Abhay is the complainant himself. They are all relatives, very close relatives. And on the next morning, my lord, they burnt the entire city.
What is your apprehension with regard to this lady?
They have.
We'll come back.
Because, as of now, because I think all we are submitting was that let the complainant be examined and after that, because
Don't take you from what we are asking. What is the,
They have already influenced the entire investigation. I have handed over
who?
these accused people, Your Honor. See the shoddy.
We'll not be letting out others. We'll let out this lady.
See the shoddy manner in which they have conducted the investigation. The witnesses who were naturally present in the vicinity of the house, they have not been even made witness.
You know what is the steps to be taken for that? It is for you do it.
And even the blood-stained clothes of the accused persons have not been seized, Your Honor. They the manner in which they have
If
arrested.
you say this, automatically then it is a case, it will be a case for acquittal.
No. One, they have done it, but I'm just pointing out how they have influenced the investigation. My lords, at least eyewitnesses should be examined, and then
So in the event, if they want to pose any threat or inducement or coercion, especially by this lady,
it's basically a clash of communities. They have registered FIR, multiple FIR against all the persons, Your Honor. After this incident, when the police was not registering our case, some unfortunate events happened. And everybody who was a witness, they were roped in other cases, even though they were not present. So this is the manner, the pressure they have created. So my respectful submission is that at least eyewitnesses may be examined and thereafter her bail may be considered.
who are those two eyewitnesses? That is
The informant was
Abhay and Pratham.
Abhay and Pratham. What is it? You said the charge has been framed.
charges have been
Charge
When
only
is,
two
when
witnesses.
is it listed for trial?
No, none of the witnesses.
10th of December.
Date.
Huh? Then tomorrow. Then you examine these two.
They'll have to find.
Then you can't say that we'll examine them at the end and then keep them inside.
I leave it to your lordship, as you lordship.
My lord, they burnt my shops, of my family. They burnt all the shops, the vehicles, not only of my family, they burnt the entire market on the next day. They say that I'll be influencing the witnesses. These people, the complainant side, Abhay and all, they are all accused in those matters.
You have lodged the FIR.
No, everyone whose shops were burnt, whose vehicle was burnt,
Why, what was the
they
reason?
set fire in the market which was owned by us. So even my tenants' shops have been burnt
As a retaliation to this.
as a retaliation to this incident.
This will go on. Which state?
My lord, the state's counter at para 15 also mentions about that.
Counter-proof.
Counter of the state, para 15. Para 15, my lord.
I'll just pass on a copy.
What does it say?
Not there.
Yes.
Counter there. Paragraph?
Paragraph 15, my lords, which is the page. Page 4. It is submitted that the incident has caused extreme anger and unrest in the locality, leading to blockages, protests, and arson incidents aggravating social tension between two communities.
When did this incident happen? Date of incident?
This is, my lord, 15th of
17/5/2020.
16th is the date, my lord. 17th, the FIR was lodged.
Not even 5 months. Not even 5 months.
But
And look at the next sentence. Bail to the accused, especially one attributed with an active role, may revive unrest and disturb the public order. The apprehension of the police is justified. And you will start. You have burned 4 shops, we are going to burn 8 shops.
My lord, they were the
Big part
aggressors.
that will
They
be
were
the
the
right.
aggressors. My lord, may kindly see, I filed the memorandums also.
It should be
They
there
were the
inside for
aggressors.
some time.
Who will go for a compromise at 12 night, midnight?
These things will happen only in midnight.
They were abducting my daughter and my son retaliated. This is the only. Otherwise, who will go to somebody's place at 11:50?
Let the complainant be examined. 2 witnesses, these 2 prime witnesses, eyewitnesses be examined.
So it may be kept pending, my lord.
No. You will liberty to go to High Court. Having heard the letter, the counsel appeal for the petition. And on perusal of the reports, we are not inclined to entertain the petition. It is dismissed. Our liberty is reserved to the petitioner to revive the prayer who will be examined by the prosecution at the earliest in the light of charges having already been framed against the accused.
And so hell you blessed.
Intervention application allowed.
Right.
There's one item 45, Lordship, call that.
Of 13th. So 12th January. So 13th January. 13th.
So time to be indicated.
Mention it all that day, definitely.
Yeah, okay, I'm obliged, all right.
41 item is 2 o'clock matter. 41.
41.
41. So what is
2 o'clock, it is listed at 2 o'clock. Which is that matter?
item 41?
One second, Mr. Luthra.
I'm completely free now.
I'm there, otherwise let my lordship do.
This is that specific performance.
That's right.
We are in the midst of a parted matter.
So whatever my lord says, whichever way, whatever is convenient.
We'll have it next week.
May I say one thing, Malaj? May I say one thing? I am appearing.
Yes, Mr. Singhvi.
Malaj, I am appearing for the respondent. Malaj, I am appearing for the respondent. This matter, Malaj, will take some time. Your lordship needed a whole. Your lordship may put it in.
But it could be next Tuesday.
You have muted yourself, Mr. Singhvi. Please unmute.
No, Malaj, nothing is being enforced. We thought we'll argue it at some Malaj detail. So lordship may have it in
You are
January.
appearing for whom?
For the respondent, full respondent.
For the respondent.
Your Lordship's order had said half an hour each, already the 13th October order. So to say that it will go on for a while, your Lordship's order has said.
No, but my learned friend is protected. He cannot have a grievance. He's protected. I am the one, Malaj, who has the order against me.
We'll have it next week, Mr. Singhvi.
Yes, next Tuesday.
Tuesday there is so many
Personal difficulty.
But
you can take it on reopening.
It may be better in January,
No,
but I leave it to my
It
lordship.
would be next.
He's fully protected, Malaj. He's fully protected.
Next Wednesday.
Malaj, the petitioner is fully protected. That's why I was saying.
Your Lordship have it in January, my lord. Next week is the last week.
17th.
Next Thursday, 18.
18th.
Can I request that, my lord, if it could be in January?
No, please. Next.
My lord, the request.
Nothing is, please wait. They have got a big task.
No, I. My lord, let's keep it on the 18th.
18.
18th.
Is that you have entered into a subsequent agreement that you will have to explain. Now, whether you have a subsisting right or not, you have entered into a development agreement
That agreement is not on record.
no, it is produced by way of.
Yeah, you know.
It's been rejected by the High Court and this court also.
My lord,
I point that out. I point that out.
That was earlier pointed out. Despite that, your Lordship's
No, I'm
directed.
sorry.
Just a
That
minute.
order can't be reviewed.
Just a minute.
That order cannot be
Just
reviewed.
a minute, that your Lordship's directed
Yes.
that both the orders, including the JDA, be brought on record. So merely saying that that can't be considered, it's your Lordship's order. I'm not saying so. Your Lordship's specific order on 13th said, please bring it on
You
record.
remember, sir.
No, your Lordship is right that your Lordship passed the order because your Lordship wanted to peruse it. But we brought it to your Lordship's attention that the Bombay High Court had rejected, my lord, their application in 4127. And, my lord, they came up before this court and the SLP was also rejected, my lord. So that document was not brought on record, my lord.
As simple as this. If you are very technical on that, then we will go. This is virtually an appeal. Then we will have to examine for that purpose whether that application under Order 41, Rule 27 could have been dismissed or not. Again, we will have to examine. That is also an issue. Please have some patience. In our last order also we have said,
Yes, my Lords took note of both the Supreme Court and High Court orders and said, please.
along with the enclosures to the said application, namely the agreement dated 31/12/2005.
That's right. That's your Lordship.
Why do you shy away? Are you not a signatory to that agreement?
But may I just point that out? What happened? Let me explain.
Yes.
They did not place on record that agreement of the SLP order or the Bombay High Court order. Your Lordships, my lord, produced the synopsis and said, what is this agreement?
Yes.
So your Lordships then observed, let this be placed on record. So we placed it on record. That's all, my lord. Yes.
What does this 31/12/2005 agreement? What does this agreement say?
Yes.
See, your agreement to sell between the parties was, when was it entered into? On 18/3/2002.
But there's something very important about this agreement. Our agreement with them is for a larger parcel of land, which is 1 lakh square meters.
Okay.
This joint development agreement is only for 20,000 square feet.
20,000 square feet.
20,000.
Now,
And it's a development agreement.
one second,
Yes.
joint development agreement.
Yes, it's only
Now,
development.
that is, you have entered in,
Yes, of course.
in anticipation that the sale, that your proposal you also. Did you have a?
No, not proposed, subject to getting the clearances.
Yes.
Subject to getting the clearances. We'll show that one. We'll show to the Lord.
This is one aspect which is loaded against you. This is the only aspect. The rest, they have an appeal task. We can.
We'll show to the Lord.
Prima facie, subject to what you both, you may argue.
Certainly not. We'll show it to the Lord.
And we thought good sense will prevail upon both of you and you will arrive at a settlement.
Lord, we
If you are
tried.
not interested,
Lord, your Lordship records, Lord, we gave an offer, but there was no response from the other side. I told your Lordship.
obviously your offer was not attractive.
Whereas they gave for a 25-acre plot, which they value at 300 crores in 2009, 400 crores, and now 1,000 crores. They said take 28 crores.
According to the value of the plaintiff.
14 crores.
Suit schedule properties.
These balance?
How much it was valued for the purpose?
By them in their suit at 386 crores in 2009.
Lord, that's not correct because those are damages I was claiming. My Lord, see the relief and my Lord, the cause of action, the jurisdiction paragraph. It was damages which were claiming, not the value of the property.
Subject to what you may say.
Yes, Lord.
We recollect that the value for the purposes of jurisdiction is 380 crores. For the purposes of court fee, it was 14 crores.
Right.
No, I'll have to show to the Lordship. I'll show to the Lordship on the 18th. My Lord, I'll show to the Lordship on the 18th, my Lord. There's no problem. I'm not going to shy away. I will show the suit plate, my Lord. 386 crores was a damages, my Lord, and compensation.
14,
Yes, and 14 was what we had paid. That's how 400 crores was arrived at. I'll show to the Lordship on the 18th.
Can damages ever be claimed, be hoarse and removed from the fact of what the value of the property is, my lords? Is there some speculative charge that they are making?
Any can explain to your Lordship on the 18th.
We are putting you on notice.
Yes, my Lord.
Page number 568.
Yes, of course. My Lord.
Paragraph 54 of your claim.
Yes.
For the purpose of court fee and jurisdiction,
Yes.
the plaintiff values the suit for rupees 400 crore, 24 lakh, 11,200.
Yes.
And have paid full court fee
Correct.
thereon
Correct.
for rupees 3 lakh.
Correct.
So even according to the value is 400 crores.
Not value of the property, my Lord. I'm so
For
sorry.
court fee and jurisdiction, you have valued the suit.
My Lord, just value the suit, not the suit property. There's difference, my Lord. And please see para 47 and 562. 562 explains the breakup, my Lord. My Lord is absolutely right. It's the value of the suit, not the suit property. The Lordship is absolutely right. Please see for 562 para 46. We have given the breakup, my Lord. How around 400 crores has been arrived at. And then your Lordship may see the prayer.
What is the 386 crores for what?
Compensation, you just see, from the defendants, the
Have you
side,
paid court fee on that
and
compensation?
then by way of damages for non-performance of the suit agreement. We claim. That was a claim.
We may not agree with you on that.
Yes.
Subject to what you may argue.
Yes,
Try to persuade.
Of course,
This is one thing.
persuade your Lordship. We'll
And
make an
for-
attempt on the 18th.
Mr. Kaul, you have suffered a decree at 2 stages. So it is not an
I'll-
easy task.
To the best of my ability, I'll try and persuade your lordships if I can. If I can't, I'll be out, my lords. That's all that I.
This is a decision.
Well, as I can-
What circumstances the court will
Discretion.
have section 21 of specific.
Yes, but my lords, discretion can't be inequitous, has to be on rational considerations, can't be on the basis, my lord, where a speculator takes a public trust property without asking for the charity commissioner's permission to file a suit. No permission required, is what they are saying. It is required under the statute. One. Secondly, my lord, if you value a suit and for 8 years you do nothing about it, no urban land ceiling permission till it's repealed.
And after the repeal of the Urban Land Ceiling Act, you file a suit and in 2009 value it at 400
At
crores.
that time, they expected that there will be ULC repeal act.
In 9 years, well, it's 9 years in advance, they did do nothing for 9 years. 9 years they did nothing. My lord, it got repealed after 9 years. For 9 years, no permission taken not to declare it as surplus land. After it is repealed, the suit is filed.
Two courts on facts of finding.
My lord, I can only endeavor to assist and try and persuade your lordships is all I can do, my lords. That's the best that I can do.
Best of luck.
Yes, my lords, I need all of it.
Next.
Well, 18. Well,
18.
Well, could it be 17?
No, not 18.
We have already listed.
I see.
We have
Could it
listed.
not 16th either, man?
No, 16th also.
Very. Isn't it 2
16th,
p.m. my lords are keeping
2
it?
p.m. 2 p.m.
18th, 2 p.m.
2 p.m.
Very well.
Oh, you're not?
So may I have your permission?
Yes, please.
Item 37 is on behalf of the widow doctor. The judgment of 2017 is not been implemented till yet and is not following the orders of this court. And she lost her husband during litigation and now she is 85 years old. This court was pleased to keep it on at item 37, whichever date that this court wants to.
First week of January, date there. First week of January.
So could it be top of the board if possible? I may make a mention there.
Please understand our predicament.
I know. But with your permission, I'll file.
Or mention it on
Make
it.
a mention.
Mention it on it.
That's all.
Please. Yes, Mr.
Manoj, can I?
Yes, Mr.
Sorry,
Paul.
I'm so sorry. Well, it can't be the 19th either, my lords. If possible. It's just that on 18th.
18th will be Friday. 18th will accommodate. Like, ask someone to make a meeting. Then you will be there.
Actually, Mr. Sirva is also not there. That's why
No, Sirva will come, don't worry.
he's not in India. Well, that'll be a bit difficult for him. He's not in India. It'll be a bit difficult for him.
For him, what? India, you go by charter flight. It doesn't matter.
You go by charter. He's not available.
It's to get connected by BC.
Very well. 18. Very great.
So first week in non-maintenance days.
Yes. So that on that day we can see that some progress can be made.
Yeah. Either Tuesday or
After
Wednesday.
this work is over, we take it up.
Absolutely.
It's item 45, my lords have adjourned on 20th, Mr. Kapil.
Which one?
Item 45, my lords. My lords have adjourned it to 13th January.
Yes, we already, who was there on the other side? In his absence.
I'll inform him. I'll inform him. We have informed my lords, but I'll again inform him.
You inform him, then only we'll
Very well.
change the date.
Very well.
Yes, Mr. Item 2. Yes, there are too many Siddharth in this case. Siddharth Dave, Siddharth Luthra, Siddharth Agarwal.
But there's another Siddharth who's missing, that's Siddharth Bhatnagar. So he's also, there's a fourth Siddharth, and it's called Siddharth Bhatnagar.
He's in this case?
Not in this case, not in this case. So today, your Lordship has 3 of us. But what I've done is there's a short note, which is a sign. My friends have been parsimonious. They thought we'll take one more page and not even give you an upload. That's it. Now, I've given you the facts, but just 2 things I wanted to point out. And that is really para 10. And at 11, para 11, if my Lord just sees.
Seem to have given some thesis, sir.
Lord, I think, but this is the chart, I'm sorry. But just come to para 11.
Page?
Page, not, this should be 4th page. Bottom page is at the bottom.
Yes.
But the point I make is, no CCTV or video footage showing me as doing any act of violence. That's the one point. As per the CDR,
According to you, you are not at the scene of the crime.
I was not at the scene of crime, Lord. I'll tell you, Lordship, just 2 points I want to make. Not at the scene of crime. The CDR which they have, left column, Lord, in para 11, only shows me present at the scene of crime earliest at 13/13/16. After the incident, thereafter they wait for a year and a half and they start getting these witnesses, Lord. Gold, Sunil, silver, gold, Sunil, Gyan, all of them trying to show me prior to the scene of crime. All these sicknesses, and I must say, Lord, they fill the lacuna and para 12 I point out by getting radium on 11th of March 21 and sodium on 12th of March 21. So my point is, delayed recording is the ground for discharge. I've stated so in para 13, Dilawar Balu Qurani. All I'm asking today is bail. And the point is this. The CDR supports me. And secondly,
Yes.
there are three elements that they put to me. Element one, I was involved in the issue relating to the burning of the Maruti showroom. Point two, I was part of the death of the incident which led to the death of Ratan Lal. And the third is larger conspiracy. Now, the larger conspiracy could be shown by CDR and connectivity. My submission is on point one and point two, that is Ratan Lal and Maruti showroom. I've got bail, which is valid today. This is the third case. And I've been in custody since May of 20. That's all I have to say, since 20th May of 20. That's all I wanted to say.
All.
Grateful.
Let's just 2 minutes. Well, I beg to appear in item 2.5.
1 second. Luthra, you are in.
I'm not just 2.6. 2.6. 2.6. Yeah. 2.6.
Yes. You are in 2.5.
Well, I am in 2.5. Mohammed Salim.
Your big name, sir?
Gautam Khazanji.
Yes.
Only submission is a legal submission. I am only relying on one case passed of this Honorable Court in 1996 of Shaheen Welfare Association. I believe this has not been cited before your Lordships in this matter. I am also conscious that the case was involving a PIL regarding the state of under trials in TADA cases. But the principles in this case, if your Lordships will straight away have para 9. Because that would be page 622 of the report. May I place it?
Paragraph 9.
Yes, ma'am.
Yes.
The petition thus poses the problem of reconciling conflicting claims of individual liberty versus the right of the community and the nation to safety and protection from terrorism and disruptive activities. While it is essential that innocent people should be protected from terrorists and disruptionists, it is equally necessary that terrorists and disruptionists are speedily tried and punished. In fact, the protection to innocent civilians is dependent on such speedy trial and punishment. The conflict is generated on account of gross delay in trial of such persons. This delay may contribute to absence of proper evidence at the trial, so that the really guilty may have to be ultimately acquitted. It also causes irreparable damage to innocent persons who may have been wrongly accused of the crime and are ultimately acquitted, but who remain in jail for a long period pending trial because of the stringent provisions regarding bail under TADA. They suffer severe hardships and their family may be ruined. Bearing in mind the nature of the crime and the need to protect the society and the nation, TADA has prescribed in section 28 stringent conditions for grant of bail. Such stringent conditions can be justified looking at the nature of the crime, as was held in Kartar Singh, on the presumption that trial of the accused will take place without undue delay. No one can justify gross delay in disposal of such cases when under trials perforce remain in jail, giving rise to possible situations that may justify invocation of Article 21. These competing claims can be reconciled by taking a pragmatic approach. The proper course is to identify from the nature of the role played by each accused person the real hardcore terrorists or criminals from others who do not belong to that category, and apply the bail provisions strictly insofar as the former is concerned and liberally in respect of the latter class. This will release the pressure on the courts in the matter of priority for trial. Once the number of prisoners in jail shrinks, those belonging to the former class and therefore kept in jail can be tried on a priority basis. This would ensure that the evidence against them does not fade away on account of delay. Delay may otherwise harm the prosecution case, and harsh bail conditions may prove counterproductive. A pragmatic approach alone can save the situation, for otherwise one may find that many of the under trials may be found to have completed the maximum punishment provided by law by being in jail without a trial. Even in cases where a large number of persons are tied up with the aid of 120B or 147 IPC, the role of each person can certainly be evaluated for the purpose of bail, and those whose role is not so serious or menacing can be more liberally considered. With inadequate number of courts, the only pragmatic way is to reduce the prison population of Tata detainees and then deal with hardcore under trials on priority basis before the evidence fades away or is lost. Such an approach will take care of competing interests. This is the approach we recommend to courts dealing with Tata cases so that the real culprits are promptly tried and punished. For the purpose of grant of bail to Tata detainees, we divide under trials into 4 classes. Namely, A. Hardcore under trials whose release would prejudice the prosecution case and whose liberty would prove to be a menace to society in general, the complainant and prosecution witnesses in particular. B. Other under trials whose overt acts and involvement directly attract Section 3 and or 4 of TADA. C. Under trials who are roped in not because of any activity directly attracting Section 3 and 4, but by virtue of Section 120B or 147 IPC. And D. Those under trials who were found possessing incriminating articles in the notified areas and booked under Section 5. Ordinarily, it is true that the provisions of Section 28 and 29 of TADA would apply to all the aforesaid classes, but while adopting a pragmatic and just approach, no one can dispute the fact that all of them cannot be dealt with the same yardstick. Different approaches would be justified on the basis of gravity of charges. Adopting this approach, we are of the opinion that under trials falling within Group A cannot receive liberal treatment. Cases of under trials falling in Group B would have to be dealt differently within that if they have been in prison for 5 years or more and their trial is not likely to be completed within the next 6 months, they can be released on bail unless the court comes to the conclusion that their antecedents are such that releasing them may be harmful to the lives of the complainant, the family members of the complainant or witnesses. Cases of under trials falling under Group C and D can be dealt with leniently and they can be released if they have been in jail for 3 years and 2 years respectively. And then your lordships will note certain conditions are. My respectful submission before your lordships and why I rely on these paragraphs is that your lordships, even when your lordships are considering this argument on delay, your lordships may consider a person, the role of each person individually, and see a person such as my client who is definitely not a hardcore terrorist and who deserves that liberal treatment. If I have to take the prosecution case at the highest, I may fall with the aid of 120B or under 147 category C, which your lordships may see is 3 years. Even in category B, I have crossed that threshold also of 5 years. So in my respectful submission, since I am not a menace to society, I am not a hardcore terrorist, your lordships may see it in that lens.
Are you contending that we can evaluate the evidence at this stage to form a prima facie opinion?
No, my lords, not the entire evidence, but since your lordships has heard the prosecution and everyone, at least at a level, at a deep
what level?
My lordship has heard all the allegations against the persons and my specific role. Your lordships, I have in my note, I have delineated that role. So my respectful submission only is that your lordships, while considering the delay, may also take into account a more. My lords, it's only indicative, as your lordships had held 20 years ago.
Then the proviso gives the UAPA.
My lords, the provisions in TADA in 28 and 29 were identical.
That's what. All right. Then you go to proviso to 45D. Then we have interpreted that in the 6 cases. D, which is that?
Yes, ma'am. It's 43D5.
43D5. Proviso.
Yes, ma'am.
Provided such accused person shall not be released on bail or on his own bond if the court on a perusal of the case diary or the report made under 173 of the court is of the opinion that there are reasonable grounds for his believing that the accusation against such person is prima facie true.
Yes, Manoj. Manoj, in my respectful submission, the only distinguishing factor is that in the present case, the court will come to this conclusion once charges are framed. Here, charges are not framed for whatever reason, Manoj. And this is not a case where many witnesses have happened and I have come at that stage that your lordships that the court would get that, Manoj, make that assessment.
then we like to defer this.
I'm sorry, Manu.
Then we like to defer this. So they may be discharged.
No, Malas, that's not my submission. Malas may not take that as my submission.
We are taking what you from your own submissions.
Malas, in your lordship's judgment in Gurinder Gill, actually many, if I recollect, Malas, 20 witnesses had been examined at that stage. Malas, that's why. Malas, that's my humble submission.
Oh,
Great.
Yes. I think our side has. Oh, something. Oh, yes. So you can respond tomorrow. Tomorrow. Yes. Yeah,
This is.
Okay. No, we'll list it tentatively tomorrow.
There's no need to clarify anything because we were on rejoinder now. I know.
Mr. Kapil has argued about Siddharth Dave has argued at length.
He had a lot to say, Lord. Some of us have lesser to say.
Because everyone have thrown the buck on Siddharth Dave.
Not because he's the one who can carry the weight. He is one of our tigers. So that's why we put the load in him all the while.
All right. Right. Siddharth Dave, Siddharth Luthra, Salman Khurshid, and also Siddharth Agarwal.
And Gautam
Siddharth and then say dash Agarwal, dash Luthra, dash.
Simply
Siddharth into 3 would be fine.
And Gautam Khazanchi.
Gautam Khazanchi, learned advocates appearing for the petitions. Here, the learned additional solicitor is tomorrow. Thank you.
Deeply obliged. Great.
We have received the addresses of the complainants, except one lordship, 2.4.
Who is appearing in 2.4?
This is Salman Khurshid.
You have not given your address.
I've shared that in the note as well and to the learned postmaster. In the morning it's.
The postmaster is saying
He says
give another copy of
We'll give it another.
All.
Check the Aadhaar card.
was given to me. Give the address. Type it out. Grateful. Grateful.
Item 5.
Please.
Yes, please.
Lords, coming up for bail, Lords had observed in view of the accused having undergone about 8 years, the state had to file a counter, which they have filed.
Counter affidavit has been filed in behalf of the state.
Right?
Case notes. It has been filed. Common counter affidavit for both the assailants.
Yes, sir.
My lord, please, sir. My lord, the matter, my lord, who are the first matter, my lord? It's a batch of matters. The first matter, it comes for accused number 5, for whom I'm appearing, my lord.
You are appealing for whom?
For A5, my lord, that is Golek Jani, my lord.
Golek Jani.
Yes, my lord. Item 5 alone, my lord. My
There
lord,
are
please.
two matters.
Please, Manu.
Dibakar Jani and Goleka Jani.
My learned friend is appearing for them.
Or for it through legal.
My lord, for the petitioner hearing, my lord, there has been no evidence, my lord, absolutely placed, my lord, and the only evidence, my lord, that is the ocular evidence of PW11 alone, who is the mother, my lord, has been relied by the courts, my lord. In her evidence, my lord, my name doesn't find a place, my lord. And her evidence also, my lord, being the sole testimony which has been relied, there has been lots of exaggerations, my lord, which has, for which there is a specific finding from the High Court. If my lords may kindly have page 27, if my lords may have to begin with, my lord.
Yes.
My lords have it, my lord.
Yes.
If my lords may have from the second line onwards, it is of course true that the evidence of PW line with so and so is a valid contradiction. In a case like this, when the witness, who is the mother of one of the deceased and wife of the other deceased, had seen the occurrence, etc., in front of her, there may be some exaggeration. If my lords may again come to page 28, I will take you to the evidence also, my lord. I'm just first I'm just showing the findings, my lord. My lords have page 28, my lord. Somewhere in the middle of the page is the relevant, my lord, about 4 lines from the top. But although there is a little bit of exaggeration in our evidence, such as cutting and so and so, PW11 being a rustic and so on, so it is normally found that such witnesses may have an influence and tendency to exaggerate the incident by speaking what she heard about the occurrence, and in the anxiety to unfold the prosecution story, she may have been trained to speak. So, my lord, the sole witness, my lord, that has been relied by the prosecution, my lord, the credibility is what I have read.
Where is the postmortem report?
My lords may have. The lords may have it in page 81 of Santosh, my lord, and 89 of the father, my lord. My lords may have page 81.
Deposition.
P9, please, my lord. It's a part of the deposition, my lord. The report as self, I don't check it. I'm so sorry, my lord. It's this. The original records are.
But not. You say only what is required for him. You will not say about the actual. We will have to see what she has stated that about cutting and all.
Please, my lord, that is not at all true, my lord. There is a finding of concurrent finding. What I'm saying, my lord, is that first of all, my name doesn't appear in our evidence, my lord. So there is no over.
Page 22. Let us hear.
My lord's miss. 20.
Where is our evidence?
Our evidence is at page 80 onwards.
81, is it?
Yes, please, my lord. P9. I'm sorry, my lord. It is on P11. 84, P11, 84, PW11.
She is the sole.
Please, my lord. There were others, my lord. They all turned hostile.
She also turned hostile.
Yeah. No, she did not turn hostile. She
13 turned hostile.
Please, my lord. And her, my lord, what I am placing is, my lord, that when first I'll take my lords to 84 to show that there is no overtax on me. If my lords have from the bottom of the page, my lord, the relevant portion, my lords have about 3 lines from bottom. My husband was assaulted. My husband was assaulted by the accused persons, so and so, so and so, so and so, my lord. In that, my name is not there, my lord. My lords may kindly observe. Seeing the assault on my husband, when my son Santosh ran towards the backside of my house, accused number so and so chased. In that also, my name is not there, my lord. And after that, she comes to this, which doesn't. There is no medical evidence, my lord. The ocular evidence is not consistent. In fact, she says there were some gunshots also. There was no ballistic report, no bullets recovered, nothing. So when the whole prosecution is based on one evidence, my lord, on one sole testimony, and that testimony, if it's not credible, my lord, we are at the state. I'm only asking for bail, my lord. It's not even final argument to do.
High Court also.
And I have undergone 8 years, my lord.
High Court upheld.
High Court upheld on that ground.
The leave has been granted in this?
In it, my lord's right to grant, my lord.
Not yet.
Not yet, my lord. 8 years I have undergone, my lord. I have undergone 8 years. My name does not appear anywhere, my lord. There is no overtake, even in the counter. My lord, I can take my lords to the state council's counter also, my lord. Everyone in the family has been named and I turned out to be one of them, my lord. Well, A5, I'm placing the report.
Yes, madam.
So far as the petitioner in item 5 is concerned, Milords, it is correct that no overt act has been given to him. Milords, the learned senior counsel read page 84, Milords. May I read from at that where his name is mentioned, Milords? If your lordships may have at that time accused.
One second. Page number 84.
Please, Milords, this is the evidence of PW 11.
Yes.
Milords may have at that time.
Where, which? Top, bottom, middle? Where?
Middle of the page. Milords.
Just about 3-4 lines from top. Page 84, about 6 lines from the bottom.
At that time, yes.
Please, Milords, at that time, accused Gautam Jani entered inside the house and he called accused persons, namely Sapan Jani, Tapan Jani, Kumar Jani, Dibakar Jani, Kailash Jani, Golek Jani. Golek Jani is the petitioner in item number 5. Milords, his presence and participation in unlawful assembly, Milords, overt act, my submission is that it may not be necessary. It was within his knowledge by virtue of the exhortation to kill the deceased and the weapons carried by the accused persons that the common object of the unlawful assembly was to eliminate Sindhura Jani and Santosh Jani. Milords, so far as his conviction is concerned, Milords, the Honorable High Court and the Trial Court have correctly convicted him.
He only called their names.
Please,
what is there to show that Guleka Jani was present?
Milords, this is the only part where he has been named. Milords. Subsequently, cross para 6, page 88, Milords may see his name is not there. Milords, in the cross, his name is not there. In examination in chief, this is the only portion where he has been named.
Even in the FIR also, his name is not there.
He is named in the FIR, Milords. The FIR is not on record.
FIR is named, my lord. We are not disputing that. My lord, the case.
My submission is that being member of
the eyewitness statement of this mother, PW 11, whether he has been named
in the 161 statement.
161 statement.
My apologies.
Lord, the records are before me, Lord. Huh? The records have arrived, Lord. The records are here. The records are before me, Lord.
It's here, available. Records are here.
What's this? We have
Give it to him. He will search for that 161 statement.
Please, please.
Yeah, I can.
Obliged.
Probably they would have filed it. You don't find paper books in the High Court?
Yeah. In Odisha, I think it is different.
Not there.
In Karnataka, we find, but here in the state, they don't have.
No paper books in criminal appeals.
Complete paper book. 161, my lord, evidence is there. 161. In Tamil Nadu, there is different states, my lord.
Huh?
The other 2-3 states they do, my lord. Here it's different. So the part sheet is that sheet.
Yes.
But I've given the copy of first line declaration. May I read that? I decide.
Line declaration.
First line given. I decided the efforts at the address and I am a homemaker. I got married around 3 years ago. My daughter is about 1.5 years old and she is named Lakshmi.
Where is the mother for explosion of the stove?
This will also.
For explosion of the stove. Where is the mother? Where is the Panchanama?
No, there is no Panchanama. That has not been recovered.
Then that is your story.
No, then the second declaration, and actually what the statement recorded by advocate in the hospital without the consent of the doctor, that has been taken to be a genuine dying declaration. Let's see
that she has written a letter to the Chief Justice of Delhi High Court.
That letter has been written by the advocate. That letter has been written by the advocate in the hospital, and the advocate declares the patient fit for statement without consulting any doctor, and that has been reduced into writing. That has been sent to the Chief Justice of Delhi High Court, on the basis of which the FIR has been registered after 2 months.
Who is PW3?
PW3 is the mother.
Mother of the deceased.
Mother of the deceased.
PW6?
Father. Father and PW8 brother. The deposition of brother is very important, my lord. He deposed that he went to hospital. The petitioner was there and he was taking care of the patient of the disease. Lordship may have the deposition of PW8. The trial court record has come.
PW8 is?
Brother. That is very important. May I read, my lord?
PW10?
10 is the advocate.
Advocate who recorded the dying declaration. And without consulting the doctor, that whether
should be concerned.
Before dying declaration.
When it was recorded?
It was recorded on
26
December
2008.
26 December 2008.
That is a letter to the Chief Justice.
My lord, kindly note some important.
So, alive for how many days?
She died on 22nd.
My lord, I'm giving some relevant dates, my lord.
22nd January.
One injury was on 30th October. First statement was recorded on 30th October. 19th November 2008, disease called her parents over phone. 16/12, father wrote to SDM to record the statement. On 26/12, statement was recorded by SDM. And on 26/12/2008, the statement was recorded by Advocate Neeraj Kumar and sent to the CGI. She died on 22nd January 2009. FIR was registered on 23rd October 2009. It has come to the knowledge of parents of disease on 19/11/2008. They are writing the letter to CGI after a gap of 1 month with help of an advocate, which has been treated as dying declaration. But kindly have that letter, the language of that letter. That can't be a dying declaration. That is with the aid of parents and everything, and the statement of father recorded, my lord. He clearly says that I have no suspicion on anyone. This is exhibited, my lord. Color मुझे नहीं. Sir. We kindly have this statement recorded by police, my lord, the father of the disease. This is exhibit, my lord. From middle, my lord, I have come to the hospital with my wife, where my son-in-law Bina is getting my daughter treated. My daughter is not completely well, yet and is not able to tell so much. I do not suspect that anyone was involved in this. I will tender my statement after talking to my daughter. When she is well enough, we all are getting my daughter treated at this moment and do not want any legal action now. We will inform you as soon as my daughter is completely well and fully conscious. And even brother says that I was taking care of the disease malady in the hospital. PW aided them. And assuming for a minute they came to know on 19th/11/2008, there has to be some explanation that why they wrote the letter on 26/12/2008. And nobody else was present when this alleged dying declaration was recorded by the advocate at the behest of his senior.
So it will examine.
This requires consideration.
No bail. No bail. Third, we grant to make it clear that it is not a case for grant of bail. By suspending the sentence imposed on it. Hence, the prayer for grant of suspension of sentence and bail stands rejected.
We have liberty to revive after 3 years. I think the appeal is not heard. If the appeal is not heard,
in order to be expedited.
Lordship.
Both matters. Both matters. Both matters. Both. 5 and 5. No, 6. Previous one was 2 matters. Item 7. Item 7.
Your Lordship, and for the daughter, but sister as well as the mother, were the case of the FIR was filed by respondent number 4 against the father, the son, as well as the sister and the mother, on the ground that they have demanded dowry and 5 lakh was given, and the allegation against the mother and the sister is that she has demanded the car, Brezza. If I just show you the FIR, madam. Page 22.
UAPA 406, 3 and 4.
Now the allegation against for me, the sister, if you cannot see page 22, middle malord. After the marriage was fixed, 5th line, on the demand of Anurag Tiwari.
One second. Page 22.
Yes, ma'am, page 22. After the marriage was fixed, on the demand of Anurag Tiwari, a guest house was booked by for rupees dash for the wedding in the city of Delhi, in which rupees 60,000 deposit advance by the applicant. On returning from the ceremony of Bodh Bharai, Anurag Tiwari and his family went back to Delhi, and about after a week, the opposite party, Anurag Tiwari, his father, Hanuman Prasad Tiwari, Anurag Tiwari's mother, and sister Jyoti Tiwari, started demanding.
Where are reading?
Page 22.
Which line? Top, bottom, center, middle?
Center, 5th line.
You should always take the quote with you, madam. You keep on reading. How do we know where you are reading?
I'm extremely sorry. 5th line, my lord.
Page number 22.
Page 22, 5th line. After the marriage was fixed.
From
the top, my lord. From the top, 5th line. Should I read it from
after the marriage was fixed?
After the marriage was fixed, on the demand of Anurag Tiwari, a guest house was booked for rupees 2,20,000 for the wedding in the city of Delhi, in which 60,000 was deposited in advance by the applicant. On returning from the ceremony of Bodh Bharai, Anurag Tiwari's family went back to Delhi, and after about a week, the opposite party, Anurag Tiwari, and his father, Hanuman Prasad Tiwari, and Anurag Tiwari's mother, sister Jyoti Tiwari, and sister-in-law Jyoti Tiwari, started demanding top model Brezza car and dowry. When the applicant expressed his inability to do so, the accused person above refused to marry, due to which the applicant is very upset. Till now, the applicant has incurred expenditure of approximately 3 lakhs from time of fixing the marriage to the ceremony of Bodh Bharai. Therefore, it is requested, Shrimanji, that applicant will report filed against the accused person, and the appropriate action be taken. and the FI was registered under Section 406 and Section 3 and 4 of the Dowry Act. Against this, my lord, we have filed a caution petition before the High Court.
406 is invoked.
Yes, my lord. 406 will not be applicable in the instant case, my lord. There was no breach of trust.
How 406 was invoked, madam? How 406 was invoked?
Manoj, we kindly have a short counter affidavit, page 68, Manoj.
Tell us. We will quash that 406. 3 and 4 will go on.
We have paragraph 12. There is nothing here. 3. Manoj, page 67. I will just read out my submission. Paragraph 20. It is submitted that after investigation, charge sheet has been filed, Manoj. Police has found a prima facie case of commission of a cognizable offence by the accused person, which should be tried in the court of law. A bare perusal of the FIR and charge sheet brings out the specific allegations against the petitioners, as mentioned in the paragraph. It is evident that the petitioners took 5 lakh in cash and have not returned the same. Therefore, cognizable offence under Section 406 IPC.
Which paragraph?
Page 67 of the counter affidavit. Paragraph 12. Reading paragraph 12.
Please show from the FIR. A bare perusal of the FIR and charge sheet brings out the specific allegation against the petitioner as mentioned in the paragraphs above. Please show.
It is, Manoj. In paragraph 22, Manoj, page 22, Manoj.
Who took 5 lakhs? Who took 5 lakhs?
Manoj, all of them.
What is this, madam? Please, for the sake of argument, don't argue.
Manoj, I'll just.
Please read the FIR. Come to page number 22. Read the third sentence. The ceremony of Godabari of the applicant short.
In the presence of opposite party, Anurag and his families and relatives, and in the evening at the time of Bidai, rupees 5 lakh, rupees only in cash was given to on the demand of Anurag Tiwari and his father.
So who demanded?
Manoj, may kindly see there was a specific demand of top model of Brezza which has come on in the
That is Anurag Tiwari and his father.
After that, Manoj, may kindly
yes.
Yes.
And this is an omnibus statement. The next one.
After
the opposite party, Anurag Tiwari and his father, Hanuman Prasad Tiwari, and Anurag Tiwari's mother and sister, Jyoti Tiwari, started demanding a top model Brezza car in the dowry.
Manoj,
it's an omnibus statement. Where is that? What is there to show? I am already. What is there to show that Brezza was given?
No, Manoj, the demand I'm saying, Manoj.
No, 3 and 4, that is, we need to understand what we said. 3 and 4, it will continue. For that, it will continue. Because it's an allegation, it has to be proved by evidence. In so far as this return of 5 lakhs, it was only attributed to father and son. How can his sister be robbed him? Whether the sister is married?
Unmarried. Because of that, the paper put everything in the newspaper and then my engagement broke off, my lord. Because of this reaction. That's what I said in my list of date.
My lord, the charge sheet has been filed by page 53, my lord, I'll just take you.
It doesn't scuttle our power.
Because I guess.
Sheet is filed, it will be quashed, that's all.
My lord, you may kindly see page 53, my lord.
Page number?
53. The 4th line from the top, my lord. The 4th line from the top, page 53, the charge sheet. From the entire investigation till now, the
406, insofar as the petitioner hearing, that is the sister Jyoti. Others, it will go on.
Well, that's in the FIR, she is stating the family members and the name of the mother and the sister are also there, madam. Specifically in the FIR, I've read the relevant portions in my last. I mean, it's not that there's no name, also name, something like that. Let them face the trial, fellows. And his court my have always refrained the high courts from questioning the criminal proceedings and so.
You filed a 226 or 482?
Yes, Manu.
Huh?
Yes, Manu.
What is? 226 or 482? What is it?
They say 226, Manu. In the UP, they filed it like 226 only. There's no separate 482 that way they filed it.
No, they filed 482 application after the filing of the charge sheet. 482 application is filed in Lavadar.
This is we received it from the legal aid matter, Manu. This is from the legal aid.
So the impugned order, Manods, we see this is a criminal writ petition wherein they have prayed for quashing of the FIR, and there was not to arrest the petitioner. So that the High Court has ordered not to arrest.
Where is the provision of law you have invoked? In the writ petition which you have filed,
Yes, sir.
which is the provision of law you have invoked?
Two date petition, 226 in the, what we have it here, 226. In page 34 is the bare manner. Issue a writ or order direction the nature of such way thereby cause the improved first information report. Page 34.
You are asking for quashing of the FIR. How 226 petitions are entertained? They are shocking.
No idea.
That too by issuance of a writ of suspender. How is thrown to winds?
And this is done by legal aid there also, legal aid here also.
That's what legally they have made illegal aid. What, Madam Bagel?
Well, that's there, I agree. Around the 220, they should have filed 482, but only the on 15 February, the engagement happened. And the allegation of FIR for me is on within a week. I demanded the top model Breza. But the FIR is filed in April, Manu. After 2 months delay, the FIR is filed, and I have been roped in, especially in that as a system. Otherwise, there is no allegation against.
Marriage took place or not?
No, Manu.
Marriage did not take place.
So 15 February was the Budharai. Within a week, they say that I demanded the top model Breza. And the FIR is filed in April, Manu. Delay of 2 months.
Naturally, the victim
If the
is not
FIR
a condition when the marriage is cancelled and dowry is demanded, so she not going the father would take this.
Filed by the father only, not by the FIR is filed by the father, and if the FIR only says within a week, I called up, demanded the page 22. The demand was within a week after the engagement.
Yes, completed. Why the remainder of the supported by the parties? Petitioner has been arraigned as a applicant of fraud. In FIR 176 article 24 registered for the offence punishable under 406 IPC, section 3 and 4 of the DP Act. Sought for quashing of the said proceedings. Which came to be dismissed. Which came to be dismissed on the ground. that the gravity of the punishment, gravity of the prima facie, the ingredients of the offence alleged are made out, and as such, it did not warrant interference. The marriage between, what is her name?
Jyoti Tiwari and mother. Mother, there are two petitions, mother as well as the sister.
Huh?
Mother as well as sister, two petitioners. Jyoti Tiwari.
The boy was Anurag Tiwari and the girl was Anand.
Jyoti Tiwari and Manju Tiwari.
What is the name of the girl? Manju Tiwari.
Jyoti Tiwari is the
Sister.
sister, 32 years, and Manju Tiwari is the mother, 56. Two petitioners before this court.
Manju Tiwari, we are not passing. The only sister, Gayatri Tiwari. Jyoti Tiwari. No. Marriage with whom it was solemnized?
Anamika was a name, my lord. And this is
marriage
was
between
Court's daughter.
the brother of the petitioner and daughter of the complainant. Was finalized on 27/12/2023, and engagement was also held on 15/2/2024. Though the marriage, according to the complainant, was called off on 24/2/2024. A settlement is said to have taken place. And subsequently, the present FIR has been filed on account of calling of the marriage. It is alleged that the accused persons demanded dowry and also insisted on specific model of the vehicle. And as a result of the denial, the accused, number one, refused to marry the complainant's daughter. It is the contention of the learned counsel appearing for the petitioner that the bare perusal of the complaint did not disclose any visible offence for the petitioner. And in the strength of an omnibus statement, the petitioner is sought to be roped in as an accused. Else she was made for quashing of the proceedings against the petitioners. But contrary, the learned counsel appearing for the state, relying upon the arguments made in the counter of the content, that in the strength of the complaint lodged, investigation has been conducted, and it has been found that the allegations made in the complaint are true, and as such, charge sheet has been filed. She prays for dismissal of the petition. Having heard the learned advocate's appearance for the parties and the perusal of reports, and the outset we would like to notice that for section 406 being invoked. The necessary ingredient is breach of trust or criminal breach of trust. In order to examine as to whether there was any such entrustment by the accused persons to the complainant, we have perused the arguments made in the complaint, which does not attribute any such entrustment for the petitioner. On this short ground itself, the petitioner number one has to succeed. Though the learned counsel appearing for the petitioner would vehemently contend that the said benefit ought to be extended to the second petitioner also, not inclined to entertain the said prayer, inasmuch as she is the wife of the Yes. Who's your husband?
Mother of the groom.
Mother of the?
I'm the mother of the groom.
She's not only the mother of the.
Hanuman Prasad Tiwari is the wife of the Hanuman Prasad Tiwari.
What is his name?
Anurag Tiwari.
Anurag Tiwari.
Anurag Tiwari is the son.
But also wife of Hanuman Prasad Tiwari, who together with other family members, including the second petitioner, had made a demand and had received some of these 5 lakhs from the complainant. As such, the relief that is being granted in the present petition is restricted to the first petitioner alone. In the light of the above discussion, we are of the considered view that the petition deserves to be allowed in part. Accordingly, it is allowed. The proceedings initiated against the petitioner from FIR number so and so, dated so and so, insofar as section 406 of IPC is concerned, for the petitioner number 1 stands quashed. It is very clear that the proceedings for the first petitioner for 3 and 4 of DP Act shall continue, and so also the entire proceedings against the second petitioner, namely for both the offences, namely that is 406 and section 3 and 4 of DP Act shall continue. With these observations, the petition stands disposed of.
One submission with your lordship being fit. With regard to section 3 of the dowry, it is about taking dowry, and 4 is for demanding. So I will only come for 4, not 3. If we can say limited to 4.
Dash it out.
Only as per the FIS, my lord, I already noted, only thing I've done is demand of dowry, my lord. Only demand of dowry. Not section 3 will not apply to me, my lord. Only 4 sections.
All. Next. Item 5. Item 5. Report. Yes. Original recording. English.
Somewhere in the middle of the page, you know, the name will appear as Bablu. Bablu. Babalu. In one place it is found. But that sentence appears to be a little incorrect, you know, because her son's name is also there along with those names. If my lords are in the middle of the page, Babalu.
You will underline to the pencil.
It's original. Right.
Pencil, pencil.
Please, my lord, please.
That's a relevant.
That is the only place it appears.
See, the power will become central and also discussing.
What she says, my son, her son's name also appears there.
This is the statement of whom?
Of the mother, my lord, PW. The same mother, my lord, whose deposition I had read, 161 statement of the mother. Same person.
Who is said to be the eyewitness?
The police, my lord, the only eyewitness.
We are unable to understand by what you want to contend in this.
My lord asked for the 161 statement. I'm just pointing out. My lord, my contention is that in the evidence nowhere his name appears, my lord. The state has also agreed, my lord. We offer bail because he's undergone 8 years, my lord. The only, for the presence, to the extent of presence, not to overtact. What I'm submitting, lord, is the petitioner here. There is no overtact against him. He's undergone more than 8 years. Today it's for consideration.
What is presence?
Please, my lord. Today, the overtact, my lord.
One is overtact. What is presence?
Presence, the defense is he was not present, my lord, which during the time of the arguments I will persuade my lords, my lord. As of, that is from the 161, but the evidence is totally contrary. My lord is having the 161 statement.
So you are contending Golab Jani's name does not find a place.
Golab Jani, my lord, it finds it as Bablu, my lord. His alias name is Bablu.
Dibakar Jani, Bablu Jani.
Please.
How do we know that Babula is Jani is?
His alias, my lord, it's there throughout the records. There it is not Golab, it is Bablu. Placing the case in all fairness to me.
What is it? My younger son, Sushant Jani?
That is what I'm saying, my lord. There appears to be something incorrect. I don't know, my lord.
I think this is it.
As it is. Must be, my lord. I've just placed it as it is.
We come across only a horrible translation and horrendous translation.
My lord, today I'm for bail. I've undergone 8 years, my lord. And my lord, there is no overtact.
Where is the original?
Original, I'll have to again.
What is the original? The original, which one? Which state? Orissa.
Orissa.
We don't know whether they would have recorded in Odisha.
You can read.
He can record.
That is the record. You will have to call for the record, but we are not supplied the copy of the record. And when you ask the registry,
it is normally the other.
Overtact attributed to
that, but he can be prosecuted.
In fact, my lord, the whole family was
His
made.
brother exhorted to kill. Gautam Jani, his brother. He's the one who exhorted to kill. He responded to that call and entered the house. That much is reflected from the record of the case.
It is a mob.
Please. And there was also a free fight, my lord. When accused had.
Anyway, he has completed 8 years. Okay. Give the benefit.
The rest of the accused role is different. 5.1, the accused persons, the role assigned is different. This is only 5.
1 second. What about the other one?
Yes, there are 4 accused.
Yes, sir.
Your ultimate I see.
Who are you?
I am Dibakar Jani, Your Lordship.
Huh? Dibakar Jani.
Sapneswar Jani, Gautam Jani, and Kailash Jani. If Your Lordship may kindly see the statement of PW1. Once at one stage, she said the incident has taken place in Kras, Your Lordship, outside in ditch outside the house, where only she mentioned the name of Kailash and Dibakar and Gautam. And in the cross-examination, the High Court has relied, if Your Lordship may kindly see page 25. Name, she has not given the name of the accused. And she stated that incident has taken place inside the house. Whereas, having the incident taken place, she fled away. Your Lordship, may I read 2 pages?
Read the 160.
Once legal aid matter, I have been assigned, Your Lordship. No role had, and we have been served. The petitioner 1 and 2 have served more than 13 years, and 3 and 4 more than 12 years. And only on the solitary evidence of PW1, which is
Dibakar Jani, how much?
13, more than 13 years, Your Lordship.
What about Sapneshwar?
Sapneswar is also more than 13 years. Gautam Jani is more than 11 years, Your Lordship. Almost 12 years, and Kailash Jani also almost 12 years.
The leave has been granted in this appeal?
No, my lord. It is coming after notice.
Not a grant.
It requires consideration, Your Lordship, on this solitary evidence of PW1. Because the injured witness, who is PW13, he is the son of the complainant informant. He has not identified any persons. And these are the 7 accused persons, Your Lordship. 5 have come to Your Lordship. And mob, which entered into house, it is very difficult for PW1 Ahilya Jani, who is mother, my lord, to identify.
Why difficult to identify?
Because she stated, Your Lordship, along with the accused persons.
Where is the evidence?
Yes, Your Lordship, in this, my lord, page 55.
50. She is Ahilya Jani.
Yes, PW11, Your Lordship. If Your Lordship may kindly see the cross, which the High Court has also quoted at page 25, where none of the accused persons have been named. Who has caused assaulted? See in paragraph.
The examination in chief.
Yes, sir.
At that time, accused Gautam Jani entered inside our home and
Yes, sir.
accused persons.
And he called accused persons, namely Sapan Jani, Tapan Jani, Kumar Jani, Dibakar Jani, Kailash Jani, Golekha Jani, Suru Jani to my house, saying to kill me and my family members. The accused persons were armed with talwar, iron rod, axe gun, hanger. First, my husband, Sindura Jani, was inflicted blows in a ditch in front of my head by means of axe talwar in front of my head. Kindly note, Your Lordship. In front of my house,
by talwar, iron rod, and thenga, causing injuries on his head, both legs. My husband was assaulted by accused persons Tapan Jani, Kumar Jani, and the petitioner, only my lord, Dibakar and Kailas. Seeing the assault, my husband, when my Santosh ran towards backside of accused person, namely Lochan, Krishna, Surup, Isnath, and Bana chased him and restrained his movement on the backside of the house and gave blows. We are not here, my lord. None of them.
Wait, Gautam is there, no?
No, Gautam is also not there. Your lordship, can you see?
My husband was assaulted by accused person Tapan, Kumar Jani, Dibakar. Dibakar is there.
Yes, Dibakar and Kumar Jani. Dibakar and Kailash Jani, your lordship.
Both are there.
No, but bottom, your lordship, can you see what she is saying?
Why do you say they are not there?
No. My lord, latter part, she has not stated their name. And only your lordship, can you see? Santosh ran towards backside of my house, accused persons namely Lochan, Krishna, Suru, Vishnutra, and Bana chased him and restrained his movement on the backside of my house and gave blows. Here, with regard to Santosh, my lord, son, none of the accused persons were there, my lord. Your lordship, last para, with the cutting of this, my lord, the High Court has said it is a contradiction because in the medical evidence it was not found out. If your lordship, can you see page 27 and 25? And now, can you see, your lordship, can you see para 5 at page cross examination? Page 59.
Dibakar Jani, Kailash Jani, from seeing the assault of women.
Your lordship,
Sapan Jani.
Sapan Jani is not before your lordship.
Huh?
He has not filed SLP.
Is the accused number? What about Gautam?
Gautam is accused number 1. He only role, he came inside and called all the other accused persons. And Sapan Jani is your lordship. He has not been charge sheeted, my lord. Your lordship, can you see para 5, page 59, the cross examination. May I read, lordship? Page 59, lordship, para 5.
Yes.
First accused, Gautam Jani entered inside house and seeing we all called the other accused person to come inside so as to kill us. Hearing the call of the accused Gautam, the other accused persons being armed with different weapons entered inside our house and assaulted all there. First, my husband and son Santosh were assaulted inside the house. There she stated outside the house. Now she is stating that inside the house. As a result of
minor contradictions.
No, my lord, no name of the accused person. No name of the accused.
It's a cross examination. You did not ask.
Yes, sir, absolutely. Can you see, my lord?
You can't take advantage of
I am not, my lord. Your lordship, can you see further? When the accused person attempted to assault me, out of fear I fled from the house and kept myself concealed inside the candle leaf bush near the Kali temple. And thereafter, my lord, she came out when her son, another son who came to the village, after in the evening, then she informed her. Then the FIR was lodged on the next day.
Anyway, madam, we are not disposing of the appeal.
Please, may I point out, if your lordship's
Yes.
an intimidating circumstance which has not been brought to your lordship's notice, my lord. So far as Gautam Jani and Swapneshwar Jani are concerned, my lord, blood stain of deceased Santosh Jani was found on the clothes seized from them. And my lord, this discussion is at page 20.
Except they all completed on more than 11, 12 years.
My lord,
Mob.
may I make a request? Because some of the other accused who are on the trial is pending. My lord, this may not prejudice the
They are
case.
responding?
Please, my lord, some of them.
Split
Split trial, my lords, I have mentioned in the counter affidavit, page 183, 3 trials are pending, 2 at the stage of evidence and 1 charge is yet to be framed, page 183. My lords, may only record who are the remaining accused. Any observations or parity may not be taken and it may not prejudice the case of the prosecution further.
Where are the others? All your family members? All Johnnies?
Your Lordship, I have received the papers
What
through
Johnny
legal
is
aid,
doing?
my lord. I do not aware about the other. Through legal aid, I have got the papers, my lord. I have filed through legal aid.
This is which state?
It is Odisha.
This incident happened where?
Andikampa village,
It
18
is
2012.
happening in
Village,
village,
is it? It's a tribal village or?
tribal village.
Having heard the image, it's a bill from the department and perusal of the records to notice that all these petitions have completed substantial part of the sentences imposed on them. And particularly, accused number, particularly the petitioners in Essential criminal number 9632 of 2025. They completed more than 11 years of imprisonment. Insofar as the petitioner in criminal appeal number 11803 of 2025. The FIR, as well as the statement of the witness pleaded 11, does not disclose any overt act attributed to him. For these reasons, we are of considered view that they are entitled for suspension of sentence as the hearing of the present appeals likely to consume time. Hence, they are ordered to be, these sentences are imposed on them, are ordered to be suspended, and they are ordered to be enlarged on bail on such terms and condition as the jurisdictional court deems fit. Yes.
Definitely.
However, it is made clear. Take it up. The learned counsel appearing for the state has brought to the notice of the court, this court, that there is a strict trial against 3 accused. And it is made clear that none of the accused against whom the strict trial is proceeding to be entitled to claim any parity. That's all.
Then your Lordship may grant leave and
Beginning, but leave granted as per the
definitely.
obliged. The hearing is expedited since the court LCR has been received.
Obliged.
No?
Short copy of it, right?
Not may observe a sentence that.
I have the history to furnish the soft copy of the records, trial court records to the respective learned advocates. Namely, both the petitioners as well as the standing counsel appearing for the spot.
Obliged.
May I mention item 35? My lord, interim is till today. Item number 35.
35.
My lord, interim may be extended.
Oh, if you want to extend it. Yeah.
Item 45, the motion senior advocate Mr. Kapil had mentioned, asking for a date. I had informed the other side, they're also here, Your Lordship.
You want it on?
20th January. Your Lordship had given a date of 13 January.
No, he said 15.
20th.
Yes.
I am entirely in your lordship's.
No, I think Baso Prabhu Patil. He came and made a mention. I told them until you come, we will not change it.
But I am in your lordship's hands.
If you have no objection, we will make it on 20th.
Item 40.
20th.
Lordship,
Which is that item?
45.
45. We are given the date as 13. Change it to 20th.
Item 47, Passover item 47, anticipatory bill.
I think we have passed over for the year.
Up to 4.
Sorry, no. No, we're not.
I tender apology, my lord.
We are not. Sorry, sir. We are not listed in first week of January.
My lord, this part of the week.
No, take this matter in the supplementary list.
No, my
Last
lord.
moment, we
Now new as per the
file at 2 o'clock in the night. Don't come.
As per the new notification, my lord, whenever it is numbered, it will be showing in next 2 days, my lord. My lord, I have a matter in court 13, my lord.
No, you will be there in 13.
No, my lord, I tender apology.
No, please.
No, it is anticipatory bail, my lord.
Or what is the offence?
Same all offences of 111-303, sorry, 105. Similarly situated a person in the same order.
Next to
Your Worship, item 24, if I am mentioning words. I am requesting for a specific date, 20th January. Please. Item 24.
What is the urgency?
It has been listed quite a few times.
Item number.
That's the specific date I am requesting.
It will come up.
Item 18, if I may kindly mention. Some pensionary benefits which were to be given, some benefits which were to be given to us, an interim order is operating against us since 2022.
Nothing. No.
Next week.
Item number 15.
Wetland. Follow Subramania.
May I mention item 27?
That may be.
No, sir. Next week, it will only admission day with Subramania. We'll have it in January. 3rd week of January. Like wetlands. We'll have to issue some directions in that.
We had filed
Your 3 applications are also pending. You consider.
We had filed a status report.
May I mention item 27?
Yes.
Matter is listed for the final arguments upon the compassionate appointment. The matter has been delayed for the 15 years.
Compassionate appointment.
Please, Your Worship.
So you are the beneficiary of compassionate appointment. So for 15 years you have not got employment.
Yes, Your Worship.
So another 2 years nothing will matter. No urgency.
Yes, Your Worship.
It will come up. Don't.